Robert, welcome to Latest TV. So unprecedented times in many ways have put pressure on professionals from all fields, and obviously increased pressure is going to enhance the chances of risk and ultimately mistakes to be made. So what common misconceptions do clients have when exploring a potential professional negligence claim?
Morning, Stephanie. Thank you very much for giving me the opportunity to say a few words about my or one of my areas of expertise, professional negligence. In one sense, in answer to that question, it is so varied because the clients that I look after are so varied. Some are very sophisticated, some less so. But I think the main misconception that I come across with perhaps the less sophisticated clients is they presume that all the loss that they suffer after the professional has made the mistake is recoverable, and it's not. Only the losses that are caused and reasonably directly by the professional's error are recoverable, and they can't be what lawyers call, say, term as too remote. So they need to be reasonably foreseeable or arising naturally from the error. Another error is almost the reverse. The clients come in and their focus is almost entirely on their emotion.
Right.
They've been let down by a professional and they are angry or worried or some other type of negative emotion, which, as we know as humans, is a big driver, but not necessarily a sensible driver for action. And what I try to do is to get the client to focus on what the recoverable losses are.
Right.
Which leads me to my third answer to your question, which is that in almost every case, the client should be driven by commercial considerations as to whether or not to pursue the claim, not emotional reasons.
Sure. Okay. And how do you support a claim to be resolved for a client?
In a number of different ways, but I think that for a client to make a sensible commercial decision as to whether or not to pursue the claim, they need at least 4 key pieces of advice or information. The first is how good is my claim? How likely is it that it will be successful? What's the value of the claim? If it's successful, how much compensation am I likely to recover? What is the process by which that will be achieved? And fourthly, what is the cost? And also, how long will that process take? And with those key bits of information, the client can then get to stage 1, as it were. And stage 1 is deciding whether or not to pursue the claim, and also how it will be pursued in terms of funding. Which leads me to my second way in which I help clients, which is if it is appropriate, and it isn't always appropriate, I do share the risk of the litigation with my client. And I do that in a number of ways. I act on no win, no fee. We call it conditional fee agreements, but the press says no win, no fee. Which means that I don't get paid anything unless and until I'm successful, and then I get paid what I would have normally been paid, plus an uplift, a success fee, and there's the rub. So watch out for that, for the success fee. I just like to just say a thing about costs, or the recoverability of costs, which is an important consideration for the client. In this jurisdiction, the successful claimant would invariably recover his or her or its reasonable legal costs from the unsuccessful defendant. That's normally about 70% of actual costs. So on a no-win, no-fee, you haven't paid any of my fees until we're successful. And then when we're successful, you pay my fees, and you get about 70% of that back from the unsuccessful defendant. But you don't get any of the success fee back. So the success fee is paid entirely by yourself. So that is why they're not always appropriate no-win, no-fee.
Sure.
Because if you are successful, you will end up paying more legal fees than would otherwise have been the case.
Sure.
Now, they do take away or they reduce the risk because you don't have to pay anything unless you're successful. They're good for cash flow because you don't have to pay any cash until you're successful and when you're successful. But if you've got a good claim and you can afford the fees on an ongoing basis, you may think that it is better to pay on a privately funded basis, the traditional way, because in that way you will end up paying less legal costs than would otherwise be the case, and therefore you'll be able to retain more of your damages.
That's really interesting to know, because I think there are a lot of members of the public that may have potential claims that might be put off from pursuing a potential claim with a solicitor or a conveyancer due to thinking that they may not necessarily have the available funds at that time. So that is interesting to know. And
it's certainly a very important part of the access to justice, and it is something that I and Healys fully engage in. We do it for profit. And so we don't do it in every case. But I actually find for the smaller claim, for the claims of sort of between £10,000 and £30,000, I say small, that's a lot of money to you and me, but in litigation terms, they're fairly small claims. I often find that I need to spend quite a bit of time with the client advising them of the disadvantages of a no-win, no-fee agreement. They know the advantages because they've heard it in the press. So the disadvantage being that if you're successful, you pay more in legal costs. There are other types of risk-sharing retainers. There's a hybrid CFA, which is the same principle, but you pay, say, 50% of the fees on an ongoing basis, and then 50% is dependent upon success. And because that is less risky for the lawyer, because they're going to recover 50% of their fees in any event, the uplift will be lower.
Sure.
There are contingency fee agreements, which we do, and that is where the amount of time you spend on the case is irrelevant. Your fees are referable to a percentage of what is recovered. So if it's 20% and you recover £100, then the client will get 80 and your fees will be 20. Now, I find that that type of retainer is very popular with clients because a lot of my clients are, or I'm able to obtain an early settlement for a lot of my clients in these types of claims. The contingency fee arrangement is inappropriate or illegal for litigation, so you can only use it up to but excluding the commencement of legal proceedings.
Sure.
And then there is also a damage-based agreement, which is the same as a contingency fee agreement. It's a different animal, but that is appropriate for when litigation is ongoing.
Sure, okay.
So you can go from a contingency fee arrangement pre-action to a damage-based agreement post-litigation or post the commencement of legal proceedings. Just finally, in terms of the assistance I can provide clients to enable them to have access to justice, to enable them to pursue their claim. I mentioned recovery of costs. Of course, the reverse is if you're unsuccessful, you're going to have to, or it's likely you're going to have to pay the reasonable cost of the successful defendant. So we can take out insurance for you, which would cover that. And also we have access to funders.
Sure.
So the funders could fund the disbursements, court fee, counsel's fees, experts' fees, that sort of thing. And indeed, if necessary and appropriate, funders will also fund the lawyer's fees as well, or some of the lawyer's fees. So there's an array of options for the client that in appropriate cases I'm able to access for them.
That's really interesting to know that that support is available. And coming back to the firm that obviously makes a profit from this, you're an expert in your area, and from what I understand, you win 95% of your clients' claims. So if somebody was listening to this and they were unsure, would it be fair to say that it'd be worth dropping an email to you outlining their potential professional negligence claim, and a professional solicitor like yourself is going to provide honest feedback, and if there wasn't a potential claim there, you would advise as so?
Oh, yes. I mean, our strapline is we win 95% of our clients' claims. That might be thought to be slightly misleading because I include in that if a client comes to me thinking they've got a claim for £100,000 against a negligent conveyancer and I don't think there is a claim, I will tell the client that. And so hopefully the client will take my advice and not spend or waste his or her time and money on pursuing a claim that is not going to succeed. I consider that a successful piece of advice.
Sure, definitely. What are the key do's and don'ts if a client thinks that they have a potential claim against a solicitor, Robert?
many. I'll give you a do and a don't.
Okay.
So the do is, do make sure that you take independent legal advice from a competent professional negligence lawyer. One way in which you can establish whether or not the lawyer that you're thinking of engaging is competent is you can go onto a number of directories. There's Chambers and Legal 500, and they will they list leading lawyers in different fields, including professional negligence. And I've been a leading lawyer ranked by both those directories for a number of years. So that's a do. A don't is, don't overplay or over-focus on your strengths.
Okay.
Do, of course, don't forget your strengths, but I think you need to focus just as much, if not more, on the weaknesses of your claim and the strength of the professional's defence.
That's really interesting. And lastly, Robert, if somebody does have a potential professional negligence claim, what are the next steps? Where could they find you and contact you to find out more information about their potential claim?
There are an array of options for to access me, but the easiest one and the quickest one is to call me on my mobile. So call me on my mobile, 078 999 73306. I would like to say any day, any time. That's not quite true because I do sleep and I do have a family life, but don't think you're constrained to call me between 9 and 5, Monday to Friday. If I can, I'll answer you in the evening and at the weekend.
Brilliant. So you're available, and I'm sure we can find you as well on the Healys website, on Facebook, Twitter. So that's fantastic. Robert, thank you so much for sharing your legal knowledge today. It's been really interesting and insightful. So thank you so much for your time.
Oh, thank you, Stephanie.